can you file an appeal of your support order? Hi, I'm Alicia Kinchlow, the owner of Kinchlow Law, a family law practice based out of the Philadelphia area. All right, so today the topic that's on the table is, can you appeal a support order? And we're going to kind of explain and break it down a little bit, because there are some things that I think I want to make sure that you guys understand in terms of the way that the process goes and your ability to, one, get a brand new hearing, and then also to have it considered within the Court of Common Pleas before it goes to the next court. All right, so for someone who hasn't been through the support process, or who hasn't been all the way through, I'm going to explain that first, and then we're going to dive into appeals and something called exceptions. All right, so when someone files a complaint for support, whether that is child support or spousal support, it starts generally the same way, and that is a complaint of support. Now, a parent can do that, another party can do it, a spouse can do it, and even the Department of Public Services, welfare, can do it. And that's going to be a video for another day, because that's a topic I see coming up a lot, and people are not understanding how child support is being filed against them by the Department of Public Welfare. All right, so just thinking about the complaint for support, it can be filed with your county, or it can even be filed by going onto the state's website and starting an application or a complaint there. Once that's done, you're going to get scheduled for a support conference in your local county court or wherever the defendant is. So one of those two and is going to have the jurisdiction to be able to hear the case. Generally, it's where the defendant is, because that's the county that has jurisdiction over that person. Okay. Now, from there, the support conference officer is going to, generally by telephone these days, gather information, either by asking you to fax it in or mail it in before the conference, but they're going to give you a telephone date where they're going to call you and the other party and your attorneys if you're represented, and go over your documents, ask some questions, and then make a determination of support. Now, as always, these videos are for educational purposes, and you always want to speak to an attorney licensed in your area about the facts specific to your case, okay? Always, always, always. Now, once you have a support conference, generally that support conference officer is going to use the information that's gathered or that's presented and what we call run the guidelines. And that's basically because Pennsylvania has a guideline, a set of grids that basically says if you have a family where the total monthly net income is a certain amount and there's a certain number of children, this is the amount of support that should be there. That's required for supporting those children. And then it's further broken down by the percentage of each party's income. All right, I'm going to do another video on the guidelines and the calculations and some of those things there. So we're going to kind of breeze over that, because again, we're focusing on appeals and exceptions in this video. Now, the thing about a conference officer is that they don't have the same authority as a judge or a master. So the next levels are a little bit more important in terms of getting a final order or making sure that all your arguments are heard. Your conference officers are generally more lay people who have been trained. They're very smart, and they understand a lot of the arguments that are going to be made at the next level, but their authority to be able to make certain decisions is just not there. And a lot of times they will tell you that that's something, something you may raise or ask to be considered is not something that they can make a judgment call on with the authority that they have. Okay. It is important to still pay attention to these levels, because this is going to be or can be an initial determination of a support obligation. And what that means is that until you get to the next level, or until you ask to go to the next level, this may be what you have to pay or what you're going to be receiving. So take it seriously. Now, in that support conference, like I said, a lot of times they're going to run the numbers and they're going to tell you what the support obligation could be or is going to be. And you may be able to object to it right then and say you want a master's hearing, and you might have your date for your master's hearing scheduled that same day. So the hearing will happen that same day, unless you're in certain counties. But generally, you're going to have a date within 30 to 45 days from that date for you to go before a master. Now, sometimes the determination can't be made at the same time because maybe other documents are still coming in. or there's some additional information that needs to be reviewed by the conference officer, and then you'll get that notice in the mail. And that notice in the mail is going to tell you or give you instructions about how to ask for a de novo hearing, which is basically a brand new hearing. And it'll tell you the time frame and the method in which you need to request that. Okay. Now the master's hearing is going to be what we call de novo, which is a brand new hearing. And at this point, you want to resubmit all your evidence. Any relevant evidence from the time period that they're asking for should be submitted. It should not be assumed that the information moves from one place to the other, because it doesn't always. I've seen it too many times. So don't assume just because you gave it to the conference officer that it made it to your file properly and it's still there, and that the master is now going to look at it. Now, a master is an attorney who basically sits like a judge. They have way more authority, and they have the authority to be able to make decisions. They can hear evidence. They can make judgments on objections and certain types of legal arguments that conference officers are not able to make. So, for example, if you want to argue that you should not be responsible for paying spousal support because you have a defense to that, such as that spouse committed adultery and you don't believe you should be responsible for paying the spousal support, that is something that can be raised with the master that they can make a determination on. They're going to hear evidence about it, which is your testimony and any physical evidence, and then make a decision about whether or not you should be obligated to pay spousal support. Same thing with regard to maybe someone voluntarily reducing their income, or someone having income that they're not reporting. All of those things are things that they can actually consider at that level. So it's important to understand that when you have your master's hearing, and even though it's not before a judge, you should consider this your trial. And that's how I generally explain it to my clients. This is where all your evidence, physical evidence, text messages, pay stubs, tax forms, all of the documents you want to be considered need to be presented at this level, because you're not going to get the chance to do it at what we call the next level. So you want to have that together. Additionally, you want to have all your arguments, your legal arguments you're going to make. So those three that I just mentioned are just a small amount of the potential legal arguments you can make in order to argue to pay less or more support or receive more support. And an attorney who practices this area enough is, one, going to be able to prepare for those things in advance, and also be able to spot certain things on the fly. So you really want to make sure that, I always tell people, you may not have an attorney at the conference level, but when you get to your master's level, you absolutely should have one. Because again, there's a lot of different types of arguments that can be made in a lot of different situations, and some that you need to weigh against each other as well in the way that you present them, that a layperson just is not going to be aware of. Okay. And you don't get a lot of time generally from the time from your conference to your master's hearings. Often it's 30 days to 45 days. So you absolutely want to prepare for that. You want to reach out to an attorney probably before your conference, but definitely after your conference, and give them as much time as possible to get prepared for your case. All right. So once the master has had your hearing, they're going to review everything. Decisions generally are not made during that time frame. The only thing that usually happens right then, from my experience, has been an agreement by the parties. And you usually still have to wait for that to come in the mail as well. Once the master reviews everything, they make a proposed order, which basically outlines their findings in terms of income, expenses. They talk about the different arguments that have been made, whether they're going to deviate, which means move away from what the guidelines suggest, either higher or lower, based on something that may have come up during the hearing. So that proposed order is very important for you to review, and then it'll tell you how much time you have to file exceptions. And generally, it is 20 days from the day that it's on, that the exceptions were mailed out to you. And usually, on the first page of your exceptions, there's going to be a paragraph that says the date of the hearing, the date of the actual report and recommendations, and then the date that you need to file your exceptions by. So you want to make sure you follow that, because if you get outside of that without good cause, you may not be able to file your exceptions. So you really, really want to be careful. And with the way that mail is going these days, you definitely want to make sure that you file your exceptions timely. And I think I'll do another video too on exceptions and explaining that you are limited to some of the things that you can put in exceptions, and arguing them at a future level is really based on what goes into your exceptions. But that's going to be another video. All right, so this is where we kind of talk about the appeal. Now, when we think about appeals, we think about appealing from one court to another, to a higher court. Now, the way that I explain exceptions to people is that it's kind of like an appeal, but within the same court. So generally, if you do not agree with the recommendation made by the master, and not just the number, but because you believe they made a mistake, either of fact or of law. So let's say that, for example, maybe they switched the pay stubs for both parties. That's happened before, and the information just got put in wrong in the calculations. That happens sometimes. If an expense like maybe childcare wasn't included in there and there's no good reason as to why it wasn't included, that can be a reason that you want to include in your exceptions. If you feel like the master made a mistake in maybe not granting your legal defense or your legal argument, for example, that spousal argument that that there was a defense to paying spousal support, or that it wasn't adequately considered, that might be a reason to put in your exceptions as well. So you're looking at errors of fact and errors of law that the master may have made, and you're going to spell that out in your exceptions. And then what happens is that you'll get generally a hearing before a judge. The other party can have an opportunity to respond as well if they choose to. But even if you don't respond, your case generally will go before a judge for a hearing, and you have to argue your exception. So you have to argue basically your appeal. And like most other cases for appeal, you're not presenting new evidence. This is not the time for that. And most of the time, the judges are going to stop you. And oftentimes, if there's two attorneys on a case, the parties won't speak at all, because it really is about what mistake did the master make during the hearing. This is not a time to relitigate your case. So this is why it's super important for you to get everything right at that master's level, because if you didn't present it, you didn't raise the argument, you didn't present the evidence at the master's level, you basically lose the right to argue it at the exceptions level. Now, the judge will then hear the arguments and decide whether or not they believe that there was some mistake made. And if they do, you're usually not getting complete relief at that point. They're not going to generally recalculate your support order and make a new finding. What they generally do is send it back down to the master and ask the master to either fix the mistake or have a brand new hearing and make a brand new determination. All right. So basically, you're going to have instructions going back down from the judge as to what needs to be considered with a brand new master's hearing, often before the same person, unless that particular master needs to be removed from the case for some reason. And if the case is not remanded, then generally what happens is that it's denied. Your exceptions are denied. And so your whatever your order was in that case becomes your final order. Once your case becomes a final order and you disagree with it, then you can appeal it outside of the court. So the one thing generally about certain types of appeals, most appeals, is that there has to be a final order. Now, there's a lot of questions in the law, and again, this is why you want to speak to an attorney about whether certain types of decisions have the weight of a final order and can be appealed. And that is something that kind of is changing a lot over time. So again, if you want to file an appeal, or if you feel like something needs to be raised, you definitely want to speak to an attorney, because they can help you out with that. But once you have a final order from the judge on the exceptions, or if you did not file exceptions, then you can have a final order, and then that can be appealed to the superior court. And then they can take up whatever your issues are that you, again, have to outline specifically as to which mistakes were made. And generally at this point, you're looking at mistakes of law. So I hope that this kind of spelled out a little bit about the appeals and why exceptions are kind of like appeals within the court system, and why your master's hearing is so important when it comes to support. And if you have any questions, if you want to talk to a lawyer from my office, you can reach us at KinchellLaw.com, which is in the show notes. You can give us a call. If you've gone through exceptions hearings, or you had master's hearings and you had questions about it, please drop me a comment below and let me know what you think and what you experience. If you have other questions you would like me to kind of dig a little deeper on from this video, or maybe one of the other ones, put that in the comments as well. Again, these videos are for you. They're for educational purposes only. And again, if you want to speak to us, I just told you how to do it. Make sure you hit subscribe and share this video out so it can help us be found by other people like you who might find this information helpful. All right, until next time, take care.